Thank you. Welcome, everyone. My name is Leslie Orloff. I direct the National Judicial Network and the National Immigrant Women's Advocacy Project at American University, Washington College of Law. And we're very happy to be supporting this webinar today, Human Trafficking of Native Youth, Children, and Adults, Promising Practices and Response Strategies. And we want to start by thanking our sponsor, which is the State Justice Institute. And this is one of many webinars that's offered by the National Judicial Network. I'm going to each of our speakers to a few minutes to introduce themselves, and then we'll get going on the content of this great webinar. Judge Romero.
Thank you. Good morning and welcome, everyone. I'm a retired judge from Albuquerque, New Mexico, served for a little over 17 and a half years in what we call the Children's Court Division, where we were fortunate enough to be able to specialize in juvenile justice and child welfare cases. And of course, that involved the Indian Child Welfare Act and our Native brethren who may be included in our juvenile justice cases, which were more than just a few. I am also a past president of the National Council of Juvenile and Family Court Judges, and I'm honored to be here today to share with you what I've learned and I'm still learning in this area that is forever giving us more information that we need to have in order to provide positive outcomes for the families and children involved in our court system.
Judge King.
Good morning and greetings, everyone. I'm Judge King. I am currently the Chief Judge of the Morongo Band of Mission Indians. I am also a state court judge for the town of Paradise Valley in Arizona. I recently was termed out as the chair of the Arizona Tribal Court, State Court, Federal Court Forum, to which we worked on ICWA issues, NICWA issues, in a variety of different things as it relates to state courts as well as tribal courts and federal courts. Currently am on the California Tribal Court State Court Forum. And what I've been doing recently has been working on CSEC bench cards for California judicial officers, and we hope to keep that moving along the country.
Thank you. Marissa?
Oh, I was already unmuted. Good morning, everyone. My name is Marissa Perez. I am an enrolled member of the Oglala Sioux Nation from Pine Ridge, South Dakota. I am also Mexican and British American. I currently live in South Park, Seattle, on unceded Coast Salish territory. I am blessed to be the executive director of the Seattle Human Services Coalition, and forgive me if you can hear noise in the background, my printer is possessed. This Human Service Coalition of Seattle works primarily in policy and local government levels to ensure access to a healthy, safe Seattle for all of our neighbors. And part of that is our work in the gender-based violence sphere. And yeah, I also have a degree in Indigenous People's Law from University of Oklahoma and have spent the last 10 plus years working in various fields around gender-based violence, trafficking, and MMIWP. I'm very grateful to be here.
And I'm Leslie Orloff. In my role at NUAP, I'm an expert on gender-based violence as well. I've been doing work with immigrant victims for survivors of domestic violence, sexual assault, human trafficking, and child abuse for about 40 years now. And there is some overlap, surprisingly, on this topic because there's all kinds of mixed status families. So those of us that do work around immigrants need to be more aware of what's happening with Native youth and human trafficking of all kinds of peoples, including Native Americans. I'm going to as we get started today, we want to tell you, for those of you that are judicial officers in particular, and those of you that work with judges, I'm going to turn this over to Judge Romero to take a moment to tell you a little bit about the organization sponsoring this today and how judges might get involved.
Thank you, Leslie. Certainly want to extend an invitation to our judicial colleagues to begin to participate in the National Judicial Network, NGN. We do provide a forum on a number of issues, specifically human trafficking and immigration, and how we in state courts need to have that information and how we can share information in the ways that I will share in just a moment. The National Judicial Network currently, as of most recent information, is made up of 403 judges who participate out of 44 states and territories across the world. In the NGN, we have an opportunity to discuss, to share with each other judges about what's going on in our courts, particularly as it relates to the subject today, human trafficking and so forth. And very importantly, immigration, a very complex arena where Leslie leads the charge on that and invites national experts to come and share their information and the latest changes that are going on in the federal scene. We do have peer-to-peer training opportunities where by participating in NGN, many of the questions that we all have, we can pose them and hopefully get them answered. We get the information that we need through webinars such as the one we're having today, other specific trainings, and as Leslie will share a little later, the technical assistance that's available, which includes bench cards, other training materials, and tools that we can use. She can tell us more about that later and its availability, particularly of this webinar, even after it's presented today, your ability to access the recording of this webinar. If you would like to participate in NGN, the registration link will be in the chat for those of the judges that have joined us who are interested in participating in NGN.
And so that gives you a picture of where we have NGN participant judges from across the country. And these are the upcoming peer-to-peer sessions that we have planned for the NGN for the rest of the year. But and then also to those of you who are on this webinar, who are interested or working with victims of gender-based violence, including immigrant victims and human trafficking victims, we also have similar membership organizations. They're not membership, they're communities of practice that meet for family lawyers, victim advocates, and law enforcement and prosecutors. And we will make those links available. But really importantly, as the judge mentioned, we're going to follow up this webinar with a recording and with materials that experts from this panel, some of you that are experts in the audience, may wish to share with us so that we can make sure everybody has all the information they need when they are working with Native communities, youth, adults who are victims.
Just want to echo what Leslie brought up, that in participating today in this webinar, there are many folks who have way more knowledge about that than your presenters do. So your willingness to share that, whether it be today or at other times when you may be available, that will contribute to the learning objectives that we're proposing for you as a result of this webinar. We're going to all learn how to help and prevent and respond effectively to the trafficking of Native youth, children, and adults. We're going to identify the steps that as courts, and that includes not just the judges and the lawyers, but all who are court professionals who participate in court procedures. But what steps can we take to prevent human trafficking of Native youth and children? That's one of the objectives, one of the goals we will present to you today and fulfill. We're going to recognize the purposes and understand the basic provisions of the Indian Child Welfare Act, and we'll touch a bit on Public Law 280 states and what that means for this particular subject and others. We're also going to emphasize the importance of collaborating with Native communities on promising practice to prevent and respond to human trafficking of Native youth, children, and adults. As some of you have heard me say multiple times, we should not be so arrogant in state courts to think we know it all. We can learn a lot from our tribal partners, and they've been doing this a lot longer than we have in their tribal communities, and we should be humble enough to collaborate and learn from each other, especially state courts from tribal courts and tribal communities. So we have a poll coming up, and you have an opportunity to check in and see, so we can all get a flavor of who's on the webinar with us today.
Okay, and it looks like people are answering. I'm gonna let it go for a second. Encourage you to place your votes and we can all see what that looks like. About wait till it's going really fast. You're a good group, very responsive. Okay, Shannon, can you share the results or do I share them? It looks like about half of you are advocates, 7% are judges or court staff, 17% are attorneys, 5% are prosecutors, and some of the things I'm seeing people put in the chat are domestic violence professionals, parent with lived experience experts, nurses, National Immigrant Justice Center, social workers, prevention, education, sex traffic, tribal, ICWA worker, a good mix of people here today. Thank you all for joining us. Okay.
I note with some joy that there are folks with lived experience, or as I prefer to say, lived expertise. Thank you for joining this webinar, and you are among the many folks who we can all learn something very important from. Thank you.
Thank you. Oops. Over to you, Marissa. You're on mute.
Trying to find the right slide, the right button, the right mute. Thank Leslie and Judge Romero. It is an honor to be here, as I said. So I'm going to talk a little bit about the overview of trafficking in Indigenous youth, why are we here? Why this specific demographic in this specific issue? So our tribal communities, let me pull that out so that it's not a distraction. And again, as Leslie said, there are experts in the room, especially with 50% of our attendees being at victim advocates. There are definitely going to be things that I miss, that the three of us, the panelists, miss. Please feel free to type additional information in the chat if you have anything, or as Leslie said, if you have resources to offer that we can send out, please send those to us. There's some of the risk factors that are experienced uniquely by tribal communities, including our children, our youth, and our young women. So we have a history of child removal and intergenerational trauma. Intergenerational trauma, if you don't know, is simply the passing on of both genetic and environmental factors that can lead to higher rates of mental distress, mental illness, lower rates of coping mechanisms, vulnerability to substance abuse, and other things that can lead to a poor outcome for an individual. So a great example of this is the effects of the boarding schools and when they have found that when folks experience some type of extreme trauma like this, whether it be a genocide, whether it be a huge event, a natural disaster, something like that, it can change their genetic response to stress. And then that genetic response is passed on to the subsequent generations. So that is something that kind of baseline all Indigenous people. You would be hard pressed to find an Indigenous person in North America that has not been touched by the boarding schools and child removal in some way. I myself am a boarding school descendant. My grandmother was a survivor, 13 years in a boarding school. So it's something that we all, when you're working with an Indigenous person, understanding that they come with the kind of that baseline of trauma that's been handed to them by previous generations is vital to understanding how they're responding to the stress and the triggers in their own life. Poverty, we all know that Indigenous people continue to experience systemic poverty. That is a result of the genocide over the past 600 years. Environmental justice, you've heard the concept of man camps, that those were a really big deal in the Bakken oil fields in the Dakotas. We still see man camps or those type of gatherings around in an agricultural setting, in a mineral and oil mining setting. These are groups of men with a lot of disposable income, and often they are co-located with Indigenous communities because, I won't go down that whole road. That's another webinar, but environmental justice is something that affects us and can lead to higher rates of trafficking. Substance abuse, cycles of familial abuse, Those can be traced back to that intergenerational trauma I was talking about earlier, and then targeted by traffickers as exotic. So this is a huge thing for especially those of us that are mixed race. We can be marketed as anything, right? We can be marketed as Asian, as Hispanic, as Latin American, Italian, you name it. I personally, as a mixed race person, have been, I get the question regularly, what are you? So having the ability to market somebody as anything that can fit the fancy of the buyers is what this is referring to. Child welfare involvement, we will talk about that in a minute. And then lack of resources offered to search for missing youth. Historically and currently, a lot of our Indigenous youth are seen as already high risk, already runaways. Oh, they'll come back. Oh, they're out getting drunk. Oh, they're just, you don't have good control over kids. That's on you. So there's a wealth of, or not a wealth, a lack. There's a lot of stories talking about this where you hear case by case these folks that go to the law enforcement, go to the authorities, ask for help, and are told that there's no help for them. And then lack of media attention, which is something we will discuss in a minute as well. Okay, hopefully. All right, so this is a case of Kit Nasamura. They were a young person that went missing from Omak, Washington in November 2021. The investigation into their disappearance did not start for over a year. Verbatim was told the detective investigating their case said a runaway juvenile is not a crime. It's a parenting issue. An officer can't force runaways to come home because they'd been reported to the Department as a runaway, not a missing person. No detective was initially assigned to the case. That being said, if you read this article, the friends and extended family of this young person raised the alarm that what had happened to this young person was unusual. It was not just a runaway. They were missing. They would not be out of touch. There were multiple reports to DCYF and OMAC PD over that year saying, hey, there's something wrong here. Please help. Please help. Again, nothing was done until January 2023. And as of a couple of months ago, the last time I checked, this young person is still missing. So I do believe there's a hand raised. Oh, it looks like it went away, so it might have been a mistake.
Yeah, and please do type if you have comments or questions or things you want to say, type in the chat, because we don't have, this isn't set up for people to be able, there are non-speakers to speak. Please type anything you would like to say in the chat.
Great. Is this still my slide? Yes. All right, so this is just a quote from Sadie Hart talking about the foster care to sexual exploitation pipeline. As we know, all youth in foster care are targeted by sex traffickers due to the experiences that brought them to the attention of the child welfare system and their experiences in foster care. Exposure to physical, emotional, and sexual abuse make youth more susceptible to sexual exploitation. We know that we'll discuss in the next couple of slides the overrepresentation of American Indian and Alaska Native youth in foster care means that there's a much higher rate of them being exposed to traffickers, being targeted by traffickers, and possibly engaging in sexual exploitation. Whether that begins before they are 18 or after they are legally an adult, it's still exploitation that result of that targeting. Yeah, okay, I'll go to the next slide. These slides just take a minute. So we talked about the overrepresentation, that American Indian Alaska Native youth are overrepresented in foster care 2.7 times greater than their proportion in the general population. For comparison's sake, white children are underrepresented in foster care at 0.8 times their proportion in the general population. It is far more likely that an American Indian or Alaska Native youth is taken from their family, is placed into the foster care system than a white child. and 68% of missing Native children reported to the National Children were missing from foster care. So there is a direct correlation between our youth being continued to be taken despite ICWA, continue to be taken, placed in foster care, and then from there they are targeted and they are manipulated, and they are, whether they are a runaway, whether they have gone missing due to trafficking, there's a direct correlation there.
Marissa, can I interject real quick?
Please do.
This is a very important fact and item that judicial officers, when they have hearings, review hearings, and you have a caseworker that comes in and says, we can't find, or we have had no contact with the child, you need to, red flags and antennas need to go up. What happened? Where are they at? What's going on? What have you done? What are your active efforts?
Mhm.
And we'll talk more about that later.
Yeah,
I think
absolutely.
it's also important to ask the question about the Preventing Sex Trafficking and Strengthening Families Act and the requirements of that federal act to report missing kids of whatever ethnicity or national origin they are to the National Center for Missing and Exploited Children, to NCIC, and of course to your local law enforcement. It was my sad experience that many of the workers had no idea what I was talking about when I used the word NCMEC, or National Center for Missing and Exploited Children. It's our responsibility to ensure that they know what it is and that they're doing what federal law requires.
And Marissa, there was a question in the chat about whether you could expand a little before we move on, how the children are targeted and looking for vulnerabilities versus inside list of children and youth in foster care. That's the question.
Yeah, it absolutely is looking for vulnerabilities, right? These young people have already been exposed to so many different things. Their ACEs scores are already off the charts. They start with trauma when they are born, and that intergenerational trauma we were talking about, and the things that they are experiencing are often lead to distrust of authority, distrust of love, distrust of, or looking for love because they're not receiving it in their own home. They come from broken homes and cycles of substance abuse and familial abuse that our people are desperately trying to break those cycles, but it is a process. So a lot of these young people are experiencing these things at home. They've experienced racism that is still just prevalent across our nation. Some of the only
There's a system that we have social workers that will go in and determine whether they need to remove a child from a home or not. And so if they don't see Kellogg cereal, milk from Post that's in a bottle that's in the refrigerator, they think that the child may be malnourished, being neglected, not being fed, etc. So if they see cans like mason jars with canned food that have been put up for years, which is a tradition, they don't know what to look and what to expect. And so that's not a custom that they're used to. It's not, as I like to say, Peoria, Illinois, where everything is normed after. And so as a result, these kids are removed and they're placed in families that, quote unquote, can take good care of them. But how that is you present a problem for us because we're not getting paid. We're not getting our foster care share to take care of you. Or some families have foster care families for foster care kids because that's how they supplement their income, not how they really love and take care of that kid.
Yeah, so their experiences prior to foster care and their experiences in foster care, both of those can compound. As Judge said, often they're taken for no reason, right? That overrepresentation. And there are cases of that. There are cases where they experience something, and then in foster care, we all know the high rates of violence within the foster care system. So all of these lead to vulnerabilities that traffickers know how to exploit. They know how to find these folks, these young people that have been abused either prior or during their foster care experience. They know how to find folks that have lost their culture, have lost their family because they were taken unfairly. They know how to target and exploit these young people and offer them that love and that assurance and that support that maybe they aren't receiving from either their biological or their foster family. So I hope that answers your question, Leah. And these things I'm talking about are well known among the trafficking community. Like the traffickers know, oh, Native folks, oh yeah, we can get them. We can exploit them. They know what to look for. And unfortunately, often that is our youth. Oh, going back. Okay. So we're going to talk a little bit about the Indian Child Welfare Act. This was passed in 1978. In the decades prior to ICWA, 35 to 45% of Indian children were placed in foster care. As we know, that rate really hasn't gone down a whole heck of a lot, but in the vast majority, almost 90%, were with white families. ICWA has been challenged dozens of times, most recently with Holland v. Brackeen, which did go our way. ICWA was protected, but that court case did leave it open and vulnerable to further challenges. This slide simply shows the disproportionality rate. So these are those that have the highest disproportionality rate, meaning the number of children who are American Indian, Alaska Native, and then the number of children in foster care are American Indian or Alaska Native. As you can see, my state, Washington, supposedly this beacon of progressive and all those other good things, 5.1%. Oh, I'm sorry, Washington is 6.3, sorry, not Wisconsin, but even higher. So that disproportionality rate is very high. Minnesota, Nebraska, the Dakotas are horribly high as well. Alaska itself. So take a look at this and see what your state, if it is represented. If it's not, go ahead and go look for that and find out what this is as of 2014. All right, talking about media. This is another issue, is that, and if you look at these snapshots I put in here, this one is from Australia, right? There are a couple of here from Canada. This one, Tina Fontaine, was from Canada. So this is an issue that faces Indigenous people across the globe, is that Indigenous, First Nations, Native young people and women are not discussed in the media. What happens to us, what happens to our families, what happens to our children. It's been described as we go missing 3 times. We go missing in person, we go missing when law enforcement doesn't look, and then we go missing in the media. So you've heard of this, or you may have heard of this concept called the missing white woman syndrome, right? If she is not blonde and blue-eyed and not somebody that the media deems as important enough, then the information is simply not there. And a great, fantastic example of this is the Gabby Petito case. What happened to Gabby Petito was horrific and heartbreaking, but she had national media coverage. She was viral in every possible way. TikTok, social media, the media itself, nonstop coverage. There were multiple Black and brown young women who went missing under similar circumstances that same week that did not garner a single article, that were not Twitter trends. When our young people go missing, when they are being trafficked, when they are experiencing these things, just because there's not media attention does not mean that family is not looking, does not mean that community is not looking. And as we know, media pressure can create results. And if the media pressure is not there, there's really no reason other than knowledge and for the case to be solved. So this is an area that you as a community and as advocates and as judges can ensure, okay, where is the media on this? Have we released a press release on this particular case? Are we discussing it? Is the family able to talk to the media? Why is this not being discussed? Why are we not talking about this? Why are we not asking the community for help? Because that's really what it's about, is asking the community to pay attention and to help find these young people. So I believe that is.
And Marissa, you're going to be talking towards the end of this about some great examples of what communities have been doing to address this issue of silence, I guess you could say. There's not media attention. And so we'll be getting to some of that. But
Yes.
what we're going to move to now is to talk a little bit, to get into a little bit more of the details so that everybody's on the same page about what roles state courts, and I'm talking about state court judges, state court staff, child welfare agencies, the lawyers participating in state courts, what we can all do that can help on this problem and what laws are there to help move these things in a much better direction. So this question is, what are state courts' notification? What are the responsibilities of state courts in terms of notifying when children go missing? And so you can, I believe this is a check all that can apply. See, about 21% of you are answering so far. And the choices are notify the child's tribe, notify the National Center for Missing and Exploited Youth, notify the embassy of the child's country if it's possible that child, it comes from a family that includes, that's either foreign born themselves or has foreign born family members or parent. We're at about half. So Shannon, you want to show the results, and Judge King and Judge Romero, you want to talk about them? What basically, first question, Judge King and Romero, is what are the reporting requirements?
The first one, as Judge Romero said before, the first thing that you should do is notify the National Center for Missing and Exploited Children. And this question goes across the board as to a child that's missing, whether the child may be Native American, whether the child may be a child of color, child of a foreign national. Notify that center first, okay? And then the other two kick in with some very specific things if you're having custody hearings or any kind of hearings under ICWA or another act. The court needs to ask a question to determine whether that child is eligible for enrollment. And we'll talk about that a little bit more in the ICWA portion. Eligible for enrollment, or does anyone have reason to know why this child may be a member of a tribe? And then the other question I think that a judicial officer should ask before any hearing gets started as a result in child custody in a dependency matter is, does anyone know if this child is a relative or a child of a foreign national? Because if so, you have to start notifying a consulate or embassy. Judge Romero.
I think the notice requirements are very important for any number of reasons. First of all, because it ultimately and initially is for the benefit of the missing child, and also for the benefit of the court's oversight responsibility to ensure that everyone, including the judge, is doing the job they've been assigned to do. And that's hold everybody accountable, especially hold ourselves as judges accountable. So I think a paradigm needs to be established in your court, and that is, child welfare folks, if the child is missing from foster care, are you making the required notification? Are you doing it in a timely fashion? At least in my experience, we typically, when a child is an Indian child and it's an ICWA case, there are assigned ICWA workers from that child's tribe. It's important that they also know about the reporting requirements and that the child welfare worker has informed them even before, so that they can all collaborate on ensuring the tribe knows about it and that the required reports to the National Center for Missing and Exploited Children, to NCIC, are made. Further, I think in establishing that paradigm, there's nothing written that says those notification receipts need to be filed in the court record. I think it's imperative that the court require that as a process to ensure and establish that paradigm that when a child goes missing, that the notice to NCMEC, because they provide a receipt, it's not all that detailed, but it shows that notification has been made and received by the National Center for Missing and Exploited Children. Child welfare should, as a habit, make sure that's filed of record in that child's case in the court file.
I think that's excellent practice to protect the record going forward, because someone's going to ask a question, what happened and what you do, and you are protecting your record as a judicial officer, and ask your court staff and people that work in your court to help you protect that record.
And let me just say that the notification to the child's tribe and the notification to embassies, it brings other resources to help much faster by making those notifications. For example, I know the foreign-born side of this, the immigrant side of this. Embassies will hire lawyers and pay for them out of the embassy funds for the kid. They can do all kinds of other things and make resources available and provide support that could be really useful to that child, that family, that court. We've had cases by judge calling an embassy. It turns out that somebody had been smuggled over the border. Their parents didn't know they were looking in Mexico. And I'm sure that as Marissa's going to talk about later on, it triggers a process for tribes that they can get involved sooner. And everything happening sooner in the process means greater likelihood you're going to find a child and be able to provide them services.
I also want to make one note about notifying the child's tribe. Notifying the child's tribe is not calling the intertribal council that may be in your state or your locale saying, okay, we got this missing child. We just want to tell you about it. That's not really notification. It's the child's tribe or reason to know. So if you are a member of a Sioux Nation, you may have to do 6 different tribes to figure out which one. And that's what you have to do. It's not, we just did one and Ogalla didn't get back to us. So Rosebud, we're waiting to see, maybe. That's not good enough.
Amber asked a question about, are these notifications required by law? Yes, they are.
They are.
The Preventing Sex Trafficking and Strengthening Families Act, as it relates to children in foster care, but it's a practice that could be employed in all kinds of cases where you have people of color, kids of color who are gone missing. The National Center for Missing and Exploited Children does wonders. They have a wonderful facility in Washington, D.C. If you're there and have an opportunity to take a tour of what they do, I would encourage you to do that. But yes, it is a matter of law. In the state of New Mexico, it's a matter of the child welfare department's regulations that their workers are required to do that. So it's not only law, but regulation within each state that we need to be familiar of in the state that we sit in to ensure that everybody's doing what they're supposed to do. I'm going to briefly delve into the Indian Child Welfare Act. As noted, it was passed in 1978. That's going to be somewhere like 46 years ago, and we're still working on fully implementing the Indian Child Welfare Act in a standard, uniform way across all jurisdictions. And I can certainly attest to the fact that most states, like New Mexico, even though we're one state, there are perhaps 4 regions in the state that everyone seems to do things differently. The rule that was enacted through the government back in 2016 was intended to make that uniform enforcement and application everywhere. That's still a work in progress. But suffices to say that the Indian Child Welfare Act 46 years ago was intended as an act, a federal act, to correct past practices of our country, some of which Marissa's already talked about, the unnecessary removal of Indian children from their homes and not placing them in other Native families or with extended family relatives or other members of the tribe, but typically with non-Indian families, and ultimately leading to the quick termination of parental rights and adoption of those children by non-Indian families. So it is a piece of remedial regulation, federal legislation, whose purpose was to address and attempt to correct past practices of our federal government and individual states that were not being regulated by the federal government on how to do things. Some of these data points Marissa's touched about already, you can read those for yourself. But not only were they removed, they were forcibly removed. And as Marissa already pointed out, placed in non-Native foster or adoptive families. By the way, that's one of the risk factors associated with Native kids being trafficked. Federal ICWA, and I would hasten to add that there are state ICWA provisions in many states that are much more protective of Indian families and tribes than the federal ICWA. New Mexico is one of those, passed in 2022. 2022, still a work in progress, but check with your own individual state to see how your state Indian Child Welfare Act cousin relates to the federal Indian Child Welfare Act and make sure that it is being complied with. placement preferences in federal ICWA and in many states, and probably in every state ICWA provision, is that if a child is removed from a native family, the priority is to place that child with an extended family member from the same tribe. And there's a sequence of what's supposed to happen, not place that child, except in an emergency, with a non-native family. But again, that's in the federal law and in all likelihood in your state law if you have such a state. So prior to ICWA, again, the slide speaks for itself, and the disproportionality of what was going on there with Indian children being placed for a purpose with non-native families to Christianize, civilize, and ensure that those native children were being brought up in the white way, not in the indigenous way that was deemed, at least in the early days of our country, deemed inappropriate and not the best for children. But what do they know? So here are just a few states. Marissa has posted some of the data from the states in 2014. This is back leading to the passage of the Indian Child Welfare Act. And again, you can see for yourselves the disproportionality that was present in those states. Sadly, there's been some progress made in those states, but the disproportionality figures have not changed a whole lot, as Marissa pointed out in her earlier slide. So in this remedial statute, the Indian Child Welfare Act, there were a number of years of congressional hearings that led to these findings. First, as a country, our government has a special relationship with Indian tribes and the tribal members. For any number of reasons, Congress decided that special relationship included protecting and preserving not just the tribes, but also their resources. And in the first bullet point here, very important, there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children. How can these tribes continue to propagate into the future if their children are being taken away from them and they're losing their identity and their culture and their language? And the United States is a trustee, whether we like that or not, of Indian tribes. And as a trustee, protecting Indian children who are members or are eligible for membership in an Indian tribe is a top priority. At least that's what was found by Congress leading up to the passage of the Indian Child Welfare Act. These are some findings that we've already touched on, both Marissa and myself in previous slides. So we haven't, I guess I can do that with the reactions on their webinar listing on the bottom. If you've worked on a case involving a Native youth and the Indian Child Welfare Act or your state's rendition of ICWA, please raise your hand, show us that. I'm not sure we'll be able to see you, but maybe
we're seeing thumbs going up. And I think you can see it on the participants list. I don't know. Here we go. I'm seeing, yeah, some hands go up, thumbs go up. There's about 8 to 10 or 12, 15 people so far.
So there are many of you who've been involved in dealing with Indian children in these acts. There's a question in the chat from Ms. Corzine, I believe it is. Does the child have to be registered with their tribe, or is them identifying as part of it enough? The short answer is, if there's a reason to know that the child is an Indian child, whether they're a member of the tribe or not, is not for you to decide. It is, at least the system has to proceed as though that child is an Indian child until it's verified that child is an Indian child, or vice versa. If it's shown that child is not a member and is not eligible for membership in a tribe, you must proceed as though that child is an Indian child. Judge King, I think you were going to mention something as well.
Yeah, and that was a point in the Brackeen Holland argument that I know that the Goldwater Institute made, or is trying to make, as it relates to the child is not really an Indian child because they're not registered or they're not enrolled. And that's not what the plain meaning of the statute says.
And Ms. DeFord, I hope I'm pronouncing that correctly. You make an excellent point about the intrinsic value, not so much in the human individual, but the money that it can bring for claiming that child on your tax return when there's a custody fight going on. Or the point has been made many times by those surviving experts from the child welfare system that they were viewed as a paycheck for their foster families. Very often they believed they were not really loved or cared for. They were just, I think Marissa made that point earlier, there's another source of income for that family who is now serving as a resource or foster family, and not so much as an individual they need to integrate into their family and care for them and love them unconditionally. So here's a quick definition of an Indian child. And not only can they be a member, they may be eligible for membership, and that eligibility is not for the court or for the child welfare department to decide. It is for the tribe, the tribal entity that they may be related to decide whether that child is an Indian child or not. Their determination is the final word. So again, we're not supposed to impose our own determination. We must get that determination from the tribal entity that child is alleged to be a member of or eligible for membership to be a member of. There are a number of numbered items here that point to reason to know if the child is an Indian child. By the way, that question needs to be asked early and often, and not just at the initial hearing, but every hearing that you have thereafter. Not just at the commencement of the proceeding, but throughout every hearing that you have, because things change, particularly if at first there's reason to know and it's not been determined. You don't want to wait until 15 out of 22 months have passed to make a determination about whether the child is an Indian child. These numbered items in the following slides are not definitions of what reason to know is, but are helpful suggestions included in the CFSRs and also in the guidelines, as they were called, that were passed in 2016.
And a practice note, there's two things. One, Ms. Bailey, saw your comment in the chat. Yes, sovereignty creates a wonderful issue for tribes, but ICWA is a federal law that applies to federal courts, and it doesn't apply to tribal courts as we relate. Although we should be cognizant that if we do have a child from another tribe, that we give them all the best efforts possible going forward. I know that in California, we have California recognized tribes and we have federally recognized tribes, and there's some contention about who is entitled to what resources going forward. But going back over to this practice note about reason to know, as a judicial officer and maybe as a caseworker or a victim advocate or a child advocate, it's not just, do you have reason to know? Do you have any uncles there? Do you have any aunts in the courtroom at the hearing? Have you ever been to a reservation for a powwow or for a ceremony? Do you have relatives that go to powwows and ceremonies? Do they do drumming or any kind of other practices in the home that may be an indication that child may be or close to a Native American family or relative that you need to do further inquiry on?
And sometimes the name of the individual before you, as Marissa pointed out, because of different ancestry, I might, as with the surname of Romero, people may assume I'm only Hispanic, but I may be Hispanic and part of the Ute tribe as well. Why not ask the question? Even if no one else has brought it up, if no one else has a reason to know as a judge or as another court professional, don't be satisfied with what you think the answer is. Ask the question. More things that are helpful hints that may lead us to the question, to the answer that there is a reason to know that the child is an Indian child. In my neck of the woods, if I have a child in court that their residence is Tisnos Pas, that may mean to me that child is probably Navajo. Or in Alamo, one of the checkerboard areas of our state where Navajo people reside in is part of the Navajo Nation. So not just for the domicile, not just that they're in your court, but what is the domicile of that child and that child's family may be helpful hints as to whether the child is an Indian child, and you have reason to know that the child is an Indian child. So ICWA applies when the court proceeding is a child custody proceeding, and there is reason to know that the child is an Indian child. So those are two basic requirements for that determination that the child is an Indian child. What is a child custody proceeding? Here are a list of 5 things that could be and are child custody proceedings in almost any court. Foster care placements. Is this a case that's been filed in a motion to terminate parental rights? Is this a pre-adoptive placement? Adoptive placements generally that may not come up in the child welfare arena, but are private adoptions. Involuntary proceedings. Voluntary proceedings generally are those proceedings where, you know, the family that placed the child in a voluntary proceeding has the right to demand the child be returned immediately. If that, and there's no ifs, ands, or buts, you have to return the child. Otherwise, it's not a voluntary proceeding. It may be something else that warrants further investigations. And an important point, some folks say this young person who's an Indian child has been in our system for a while, and now they've turned 18 and they're aging out of the system. They do not cease to have ICWA apply to them simply because they've aged out and they've reached the age of majority, which in most states is 18. ICWA doesn't apply in divorce proceedings. Those happen in tribal courts as well as in state courts. I already mentioned about the voluntary placement where ICWA doesn't apply. And I want to add that even though it doesn't apply in a juvenile delinquency or juvenile justice proceeding, our state, New Mexico, because the Tribal State Judicial Consortium, the tribal court judges took the initiative of saying, why does the state of New Mexico's juvenile justice law say that you have to notify a tribe at the end of a case when a judge is asking for a pre-sentence report? You've already, the horse has long been out of the corral. Why are you waiting until the end of the case to do that? In New Mexico, that changed due to the efforts of tribal court judges and specifically in the Tribal State Judicial Consortium generally. The child's tribe must be notified at the very beginning of a delinquency case. And it's important, I think Leslie highlighted that earlier. If you know about that early on in the proceeding, there may be other resources available from the tribal community that can help with remediating what that child's situation may be in the juvenile justice case. So when that referral is made to the court, juvenile probation in our system is usually the first to know. The statute requires that juvenile probation must make that notification to the tribal entity, even if the child himself or herself or that child's parent objects to it. It's the responsibility of in the statute that child's tribe must be notified.
And those children are typically referred to as dual status youth. And it's important and it's an imperative that the two parties, the probation department and the caseworker, social service worker, talk to each other as it relates to those children. And then there was a question in the chat about a bench card. Yes, the National Council for Juvenile and Family Court Judges does have a bench card that outlines questions that should be asked as it relates to ICWA.
There are a number of resources available through the National Council in collaboration with the National American Indian Court Judges Association, who partner in providing the information. You can log on to any of those websites, NIJA's or the National Council, and navigate through that to find those resources that are available. Not just bench cards, but other information that's been published in collaboration with our tribal partners having to do with what our active efforts, how do we develop a plan in this instance to develop a plan to prevent sex trafficking of youth. I'm sorry, let me go back to that one slide very quickly. These are the requirements for giving notice. And in New Mexico, the requirement under the Indian Family Protection Act, which I made reference to earlier, that was passed us in 2022, at the beginning of a case, at the investigation of it, before it's even a court case, the Child Welfare Department must notify the tribe, I think within 24 hours, of the fact that an investigation is going on. And as Leslie pointed out earlier, the more people involved in helping to resolve the issue, to be solution seekers, rather than waiting until there's a problem that needs to be solved. Remember that we work together collaboratively to assist the family and to engage in active efforts at the beginning of the process, not just when a case is filed. And even though one of the things that had to be a news flash, and that was, how can we notify tribal entities? They have email and fax and everything just like we do. And you can do that. You can send an email notification. You can send a fax. And those are great in terms of getting that information out quickly. But you can do all of that, but you must not and cannot overlook the federal law requirement in New Mexico, our state court requirement, that notice must be sent either by certified or registered mail with return receipt requested. And the emphasis is on receipt. And you have to have some document that shows that the tribal entity received the notice that was sent by certified or registered mail, because it impacts on when you can begin a proceeding.
And Judge, if I can jump in here,
Sure.
what I want to say is, this is not about how quickly the court can find ways to move on with the next case. This is about making sure that people get engaged so that in the long term for this child, the right thing is done. And that actually is a better outcome, not only for the child, but for the court and the purposes of what the court should be trying to achieve. So that these notification issues are really important and shouldn't be downplayed.
And I'm going to go back to, again, I have a friend that was an ICWA court judge in Los Angeles, and Los Angeles County has no reservations within it. However, they have a large population of Native Americans that reside there, and their kids get in trouble, the parents get in trouble. They have a horrendous time, but they have to notify tribes. And it, as I said before, it's not calling the Arizona Intertribal Council and saying, hey, we got a kid, it's one of yours. But you have to try to find out what tribe that child may be eligible for enrollment in and notify that tribe. Now, I know that the BIA has a website that has contact information for various tribes, all 576 of them, on their website, so that you can get in touch with them. And if that doesn't work, sometimes pick up the telephone.
So I want to take this opportunity to also add that there are some jurisdictions where I've had the privilege of speaking where they say, we don't have any Indian tribes in our state. Why do we need to know about ICWA? Another news flash. Indian people are just as mobile as we are, as any of the rest of us might be. You might have someone from Mescalero Apache in New Mexico in Washington, D.C. in a federal job where their family is in the district or living in Virginia. And Virginia does now have, after much effort, federally recognized tribes, where before those tribes that were there when Europeans first landed were disenfranchised and not recognized as federally recognized tribes for a long time. That changes a lot, quite frankly, in other jurisdictions as well, where you have Indian people living where their tribes are not federally recognized. And as Judge King pointed out, even if they're not federally recognized, we should still afford the same active efforts protections and requirements that ICWA affords those Indian children who are members of or eligible for membership in federally recognized tribes. This slide has been up for a while. I don't need to dwell on it anymore. It should be self-explanatory. Someone asked if the presenters, the panelists, contact information would be provided. I won't speak for the rest of you folks, but Leslie's nodding her head. I certainly, to the extent that I may be of any value, she can provide my information to you if you request it. And I think it'll be posted in any event.
I concur.
So I talked about placement preferences earlier. One of the risk factors associated with trafficking of Native youth, if they're coming from a Native home where they're used to the customs, the language, and the traditions, and you place them in a priority or in an out of priority placement, do you think it's any surprise that they're going to run from that home? And as was pointed out very articulately by Marissa, traffickers are waiting for that to happen. Folks that they see that don't belong in certain situations, they can assume that they've run away from somewhere. They can assume, because of their own experience as traffickers, hey, this kid needs help. I'm going to offer them something. And it doesn't matter where they're from. If they've run away and they're in a precarious situation, they're prime pickings for the trafficker and other exploiters like the buyers. So these slides, and it's available in the CFSRs and in the Indian Child Welfare Act itself and in your own state about placement preferences. So I won't spend a whole lot of time on that. When it comes to litigating a case that's already before us, there are some requirements. In an adjudication, the standard of proof, if it's not already the general standard of proof for all your cases, in an adjudication where an Indian child is involved, there has to be clear and convincing evidence. And it has to include the testimony of a qualified expert witness or even witnesses. There's no requirement there's no preclusion that you can only have one qualified expert witness. The law specifically states witnesses in the plural. But that witness has to testify. There has to be testimony that the child's continued custody by that child's Indian parent or Indian custodian is likely to result in serious emotional or physical damage to the child. And not just that alone, there are other qualifications for that person to be a qualified expert witness that I won't go into. Be familiar as to what those requirements are and what your appellate courts have said about what the connection has to be in order for that person to be qualified as an expert witness under the Indian Child Welfare Act. When you have a termination of parental rights, the standard is even higher. There has to be evidence beyond a reasonable doubt, again, including the testimony of a qualified expert witness, and again, that the child's continued custody by an Indian parent or Indian custodian is likely to result in serious emotional or physical damage to the child. Be aware of what that entails. Again, what your own state rules may say and what your appellate decisions have determined is required under that. What are active efforts? There's really no definition. There are a lot of helpful suggestions about what active efforts are, and this slide indicates what some of those are. But active efforts focus principally on what are we doing to ensure that child is maintained in an Indian family, or that there are efforts being made above and beyond to reunite that child with his or her family. And it means more than just saying, we're going to give you a list of resources that you can go to. Transportation issues, language issues may require a whole lot more, and very often do. Not just giving them a list, but your state child welfare folks and others who are associated, giving them a ride there, introducing them to the folks and staying with them to ensure that everything that is required is being communicated in a way that everybody understands. Active efforts are to be tailored specifically to the facts and the circumstances of each case. We all know in our work as court professionals that no two children are the same, no two families are the same, and quite frankly, no two tribes are the same. And even within a tribal entity, I was taught by someone very crucial to the process of cases in the child welfare system that even within a tribe, you have different clans who have different cultural practices that are related to the bigger whole, but in order to ensure that you're dealing with, to ensure that the efforts are tailored to the facts and circumstances of the case, not only do you have to know that the child is Apache, what Apache tribe are they from, that they're Navajo, what is their clan, what are the specific facts of that child and that family that ensure that you're providing the right active efforts and that your efforts are in fact active efforts.
Active efforts are so vital in child welfare that several states are adopting that principle for their child welfare processes across the board.
So best efforts, best interests of an Indian child are defined by the federal law. Best efforts, best interests mean you keep the child in the child's family, extended family, the child's tribe, or with another Indian family. We hear too often about the child's been in a non-Indian foster home and we're 2 years into the case, and to separate the child from that family would cause great harm to the child. You're bad. That child should have been placed with an Indian family according to the law at the very beginning. More importantly, should that child have even been removed in the first instance? Are we actually dealing with active efforts if we've overlooked that at the beginning of the case?
Marissa and Judge King, what's PL 280 states and what does PL 280 require? We've been talking a lot about ICWA.
PL 280, Public Law 280, is concurrent criminal jurisdiction. It allows, and I have a different opinion, but my opinion is that there are some states that have 638 contracts that allow them to do their own criminal prosecutions of non-natives that take place within their reservations. In PL 280, that jurisdiction resides in the state and the federal government. Although the tribe does have the opportunity to prosecute its own members, most of them cede that responsibility unless they've done retrocession and allow the state to step in.
What does that mean when we're talking about trafficked Native youth?
It creates this safe haven, or the philosophy for traffickers, that if I get a kid that I want to traffic and I do it on a reservation, no one can come after me because I'm non-native. And that's got to change. I'm just going to say flat out. You have Homeland Security having their blue operation. You have the federal government through the FBI, U.S. attorney's offices, creating their MMIW task force and their trafficking task force, but yet that is not fully funded all the time, or it's given to a person that has 17 different other responsibilities to sliver out that particular part as well. What typically will transpire is I know that you have a trafficker that will have several kids. They'll take them to a tribe that may have a casino. They'll operate out of the casino because you have people that will go there and try to sell those kids or their people. And it is embarrassing because then the trafficker knows the tribal police can't do anything about me. The casino security can't do anything about me. And maybe or maybe not, if the U.S. Attorney's Office gets hold or wind of it, since they have prosecutorial authority there, they may or may not do that as long as there's no drugs involved, theoretically, or no guns involved. They may view it as a low-level crime, and we don't want to touch it.
When I hear that, it seems to me that a lot of this is to say that everything you can do early on, these notice requirements, prevention, trying to keep the kids out of foster care, it's all the more reason that all the things we're talking about, people should be doing.
Yes.
He answered this, but let's just take a poll. Which courts, lawyers, child welfare agencies need to be making these routine inquiries about whether children in the court jurisdictions, urban jurisdiction, where there's a registered tribe, where there's no registered tribe? See if we got our point across. About 26%. Wait a second more. Okay, Shannon, you want to show us the poll? And basically, I think people are seeing in significant numbers that it really does need to be everywhere. Even as Judge King was talking about Los Angeles, the urban jurisdiction, because Native children, as Judge Romero was talking about, can be anywhere. They can be in any court, anywhere, and that using the bench cards that the judges were referring to, which we'll make sure we link to, all of those kinds of things are really important for everyone. Is there anything? I think we've covered that.
Yes.
I think Judge King and Marissa, anything you want to talk about on this slide? Or any of you guys, any points you want to raise in particular about, we've been talking a lot about youth what are some of the other things we're seeing or that you might want to mention that people should be aware about Indigenous women or adults, Native adults as well?
So one thing to remember is that all of the stuff we've talked about when it comes to youth, that doesn't magically go away when the individual becomes 18, especially if they've grown up in foster care. They still experience those same areas of vulnerability. Indigenous women are targeted, Indigenous people are targeted for a lot of different reasons. The jurisdictional issues that we've already discussed when it comes to PL 280 and who has jurisdiction over an issue has created over something that happens on the reservation has created this sense of open season on our youth and our women. But the same disproportionalities around missing and murdered Indigenous people happen in urban centers and rural non-native, non-reservation areas as well. So that speaks to the sense that Indigenous women, Indigenous people are throwaway people, are not given the same level of humanity that non-native people are. And therefore, when they do go missing and when something does happen, we talked about going missing in the media. So all of these things kind of play a role. There's not reason for MMIWP. There are a myriad of reasons, and they all play a role in this crisis that has come to the forefront over the past 15, 20 years, but has been well known among Indigenous communities for generations, that when our people go missing, when something happens to our communities, nobody cares. The issues of trafficking and of children, of our youth, don't go away when we're talking about someone who's an adult. They still experience those same levels of targeting, still experience those same type of vulnerabilities. There are differences legally, but there aren't ultimately. In my mind, I'm not an expert on what can be done from courts, other professionals, but I do know that and we'll talk about some of the strategies to respond here in a minute, but I think that, yeah, my apologies for not quite having my thoughts together on this particular issue. It's a really hard issue to discuss. I wasn't, if Judge King or Judge Romero wanted to step in on this one as well.
I'll step in. The thing is that what gets me about this is that I go to a variety of different venues and speak at a variety of different places, and we talk about MMI relatives that are missing, and I have all these silos that everybody has their own program, but no one communicates across platforms to talk about what's going on with this child, what's going on with this person. Have you seen them lately? And I know when you talk about strategies to respond, you'll talk about the Alaska example coming up, which I think is very important. One of the things that I was very impressed is if someone goes missing, they have a website. They put that person's picture on that website, and so that everybody knows that person's missing, and it's not because of a feather alert or an amber alert or something of that nature. This is a response that they have determined that they're going to do in their own community to make sure they can find this person. And I think that's highly important. I said before, when we talk about a sliver of a responsibility of a federal employee in say the U.S. Attorney's Office or in the FBI office, you can't count on them to find these people for you. You can't count on them to put the information into the system. And I'm not bad mouthing them. It's not happening. Okay. So I get past that point and go, how do we make it so that it happens? And until we can find them and we use our resources to do, that's not going to happen. We got to do that. And we got to do it community wise. And we have to do it from the ground up, from us, not being told down. This square peg is going to fit in your round hole.
I think people are going to be really interested in hearing a little bit more about that. I know we have some slides here, but Marissa and Judge King, tell us about what some Native communities are doing and it's so important to the rest of us because it's important to understand what's happening in the ground in Native communities, the creative responses that are coming up, and how we can collaborate with them. We don't have to just stop at NCMEC, that we could actually help support the efforts that the tribes are doing. And so I think talking about that, I'm not sure which slide you want to do it on, Marissa, I'll let you choose that, but I do think telling people more about what those communities have done, I think is inspiring and really something we should all be thinking about supporting.
The most effective responses have been really what Judge King was discussing about those silos, breaking down those silos. Ultimately, having the tribal community, whether it be an urban indigenous community, a reservation a community, lead that effort. They are the ones that know their community members. They know particularly the unique vulnerabilities, the unique exploitation that they've experienced, the unique issues that are facing their community, and they're going to be the ones that can offer the most useful information when it comes to locating somebody. The other thing we've talked about this, we've mentioned a couple of times, the feather alert or red alert, or here in Washington State, it's called the MIPA, the Missing Indigenous Persons Alert. That has been incredibly effective because it doesn't have the same restrictions as the Amber Alerts. And it goes out to every law enforcement and prosecuting attorney's office across the entire state. It's very similar to a silver alert. They don't require a vehicle to be involved, and it's been used very effectively here in Washington State. When we're talking about breaking down those silos, not worrying about jurisdiction, but until the person is found. Once the person is found, we can have those conversations. But between now, the time that they've gone missing until the time that, I remember being on one search and trying to call 911, and we were going all the way up and down I-5. We live on these major freeways. And as we crossed jurisdiction, 911 had no idea what we were talking about. And we're saying, we've got a sighting of this individual. We've got a report of this individual. Why are there these kind of breakdowns in cross-jurisdictional communication efforts when every second that somebody is missing matters? So looking at the way your jurisdictions talk to one another, not just the law enforcement, but the victim advocates and victim response teams, the 911 operators, the dispatchers, the police, the fire departments, all of the prosecuting attorney, all of them, the way that they talk across jurisdictional lines when it comes to response for a missing person, that cannot be emphasized as being one of the major barriers to any type of effective response. And that's something that our task force here in Washington State has done an excellent job of breaking down and getting past these lines between grassroots organizers who are boots on the ground, who are looking for our people, and law enforcement who think that they know all and they know everything. Trying to break down those barriers and say, look, we are all ultimately here for one reason and one reason only, and that is to get our relative home safely. And I cannot stress that enough. So that's, yeah.
We have two judges here. Having heard what Marissa just said, what role can judges play when that's happening in your community to maybe motivate CPS, motivate police to do a better job on some of these things? Is there a role that judges can play?
I think judges need to accept the fact that not because we chose to, but because the federal government, at least in child welfare cases, and I would suggest that in all things that happen in our courtroom, we are in charge of the case. We are the gatekeeper. We're the overseer of what's taking place. So ordering things that need to be done is part of our bailiwick. That's what we're supposed to do. Once we receive the information, assess that, compare it to what the law requires. One of the things that Child Protection Services in my jurisdiction finally started doing was reporting to NCMEC when a child went missing. When probation officers in our juvenile justice system started taking seriously the need to, at the beginning of a juvenile justice case, to report to the tribe that they had a tribal member or someone they believed had reason to know was a tribal member was in our court cases, that led to better understandings. What should we look for? We should look to being, I think, as the National Council trains us judges to do, and that's be the inquiring magistrate. Ask questions. If you don't ask questions, you're not going to get an answer. Don't just sit there and say, I'm calling balls and strikes. Ask questions and get answers to those questions. I would also like to add, I'm sorry, go ahead, Judge King.
We're going to the next slide, and I would agree with everything that you just said, but your judicial canon and our obligation to educate the community. A lot of times judges sit in their chambers and don't want to get out and go talk to other people, don't want to take on issues, and don't want to talk about how can we do things better. Sometimes roundtables are good. Sometimes, unfortunately, federal government and state governments don't like to provide food, and food gathers people. And you can get people at lunch to talk about how are we addressing this problem. if you take a leadership role in that particular area, how are we addressing this problem? And again, what silos do we need to break down? How do we foster communication across the platform?
And how do we learn about what's happening in our Native communities, where are Native communities taking leadership, and how can we support them? That can be part of that whole discussion.
Having a tribal court judge and a state court judge bringing their social workers and their probation officers together to talk about, we have this issue this month, we have this issue next month. How do we work together doing those types of things?
Yeah, I think we're coming up towards the end, and I'm just going to say that victim advocates and attorneys also can play a role. It's important if to learn what if there are boots on the ground in your tribal communities that are doing these work in your area, what can you do to help them? How can you join them? How can you support those efforts? How can you become part of the solution? How can you make sure that the judges that you're appearing before are making the right inquiries? All of these things, advocates and attorneys have roles to play as well. I'm going to turn it over to Judge Romero and Judge King and Marissa for the just closing thoughts, because we're coming up on the end of the hour.
I'd like to just, before we actually go over the closing thoughts slide, just a quick reminder of the history that our government has imposed upon Indian families. I mean, we started out with the doctrine of discovery. How do you discover a country that's already occupied? Making peace treaties with our Indian communities and then breaking those treaties. And then having an assimilation policy that basically included boarding schools, the Allotment Act, and finally termination of our government's involvement in Indian business, if you will. Boarding schools and the whole part of the assimilation process was founded on the kill the Indian and save the man. What kind of process is that? Throughout the history, genocide may be a strong word to use, not just physical genocide, but certainly cultural genocide is not disputed. Indian people in our country at the hands of the government basically experienced war, genocidal acts that Western colonizers imposed upon them along with the government, and government policies and different genocidal acts were used to try to destroy Indian people. Bottom line, full stop. There was no other way to explain what happened. One can say that dehumanizing Indian people was part of it. And we can say that there was a general dislike and maybe even hatred for Indian people. But as is quoted in this slide, dislike and hatred by themselves without the power and the authority to act can be pretty benign. But those of us who work in this arena, whether we're community providers or court professionals, we are entrusted with a lot of authority and great power, and very importantly, responsibility. A question that I need to ask myself, and I would urge all of us to ask, do I exercise my authority and my power responsibly? Am I content with things being the way they are? We all know that if we keep doing things the same old way without thinking about it, history is going to repeat itself if we don't ignore the history, particularly as it has affected Indian people and others who have been marginalized throughout the history of our country. We cannot ignore history. We cannot repeat it.
Judge King, some last thoughts?
As a person whose great-grandmother is on the 1924 Baker Rolls and on the other side of the family came from enslaved people, I concur with what Judge Romero talked about. We can't have history repeat itself. And this is a passion of mine that I feel very deeply about. And so I'm going to stop there before I keep lip dripping. But I'm going to say, and I'm going to help out, please fill out your evaluations. Okay. And thank you for allowing us to bend your ear, because I suspect that many of you that were on this webinar know far more than we do.
And Marissa, would you like to say any last thoughts? Thanks.
I couldn't have said it any better than my esteemed colleagues here, but I do want to just offer thanks to you all and thank you for including me in this webinar. And please reach out if you have questions. We were the information we were not able to discuss today is vast. And as they've all said, there are experts in the room. I'm watching, I know some of these names that are popping up, and there are experts in the room. So please reach out and continue to learn, continue to research, continue to be curious and humble, and understand that as a professional, you don't know everything, and there are community members that know more. So who are you getting your information from, and are they the people that are most effective, or do they have a seat at your table? So thank you all very much, and I hope you all have a wonderful day.
I want to just finally add that, these subjects can lend themselves to a gray cloud hanging over us. This is not about doom and gloom. This is about encouraging all of us. As my dear old daddy used to always remind me, we have a whole lot more to be thankful about than we have to be grumbling about. So we can grumble if we do something about it, but let's remember to be thankful for the many blessings that we have. And again, my gratitude to all of you for sharing part of your day with us. Thank you.
Thank you. And I, in closing, want to thank our faculty, thank NCJ, FCJ. And I will tell you, there are so many experts on this. We're going to reach out to you and ask if there are things that you think are great tools that you'd like to post along with this recording. And we'll try to post some things that will make this even more useful to people who access this in the future. So keep up all the great work you're doing. And I think working together, we can all make a difference. And that's why we're all here. Thanks so much.
Thank you.